will never pretend to be another. I will never want to be another. I will not change who I am just to fit in. I am me. I am not perfect, but I'm working on myself. Working to become the best version of myself. I am working on myself to continue to expand my own self through my own work, in my own way. I am me.
Hello, ladies and gentlemen. It's your girl, Wanda Godsbratt. And as promised, I have with me Kimberly McLean. She is an intellectual property attorney, and we are all about to learn something. I'm going to give you guys a chance to come in because I think she has a little bit of information for all of us, even myself as a makeup artist and is my makeup ministry considered intellectual property, Kimberly?
It can be.
It can be. Okay. See, so we all have something to learn here. I'm going to give people a chance to come in. And of course, if you miss anything, you can play it back. So, Kimberly, you've been an intellectual property attorney for over 20 years. So, first of all, tell me, how did you get into this field?
Okay. So I have been an intellectual property attorney for about probably since 2008, but I've been working with patents since 2000. No, I've been working in intellectual property since 2008. But before that, I worked as a primary examiner at the patent exam office. So that's where the time period is a little bit longer. But as an attorney, it hasn't quite been 20 years.
Okay.
But so just to clear it up.
Okay.
So I went to undergrad at Morgan. I studied electrical engineering. I was really passionate, I thought, about working in that field. I worked at Texas Instruments. I went out into industry for a little while and worked at a couple places doing some of the work. When I worked at Texas Instrument, I had a mentor there. He ran a patent engineering program. He invited me to come to some of their meetings. I participated in a few of the meetings, and I was, really interested in getting more involved with the patents and the process of doing them. And it's such an important part of a company. And I didn't have to lose my technical background to do it, because most of the patent work that I do is electrical engineering based. I still do other stuff, consumer products, and I help mechanical products, other things like that. But most of it is still using my technical background that I already have. So just going to the meetings, working with some of the patent attorneys there, I got really excited about getting into the field. And so that's when the light bulb went off, and I decided I want to go to law school and get into patents. So I left Texas Instrument. I started working at the patent office for about 10 years. I went to law school in the evenings. Once law school was over, I left the patent office and started working at a couple of different firms. And so got my feet wet doing that.
Okay. Okay. And I do try to say hi to our guests as we come in. And so hi Jason, how are you, love? So instead of me reading, tell me, what is intellectual property?
So intellectual property, it's just like real property. You have a house. Intellectual property or intangible property rights to certain types of things. So it covers patents, trademarks, copyrights, and trade secrets. And so all of them have a different sort of thing that they cover. If you are developing something that's an innovation, you've developed something new, like a device, a process, a software app, something to that effect. And people spend a lot of time and money, and these are ideas that they come up with. You want to be able to prevent other people from kind of stealing your idea.
Mm-hmm.
You would want to find out what the proper way to protect it, and that's going to fall in the intellectual property umbrella. So for something like that, you would try to get a patent. Also, trademarks are a big thing. That's your brands. We're all familiar with Louis Vuitton, Gucci, and the knockoff market. And so the whole point in getting trademarks is to prevent other people from using your brands to provide services or goods under your brand name. Think about it. Gucci or Louis Vuitton, they spent a lot of money convincing us that they're luxury brands.
Right.
So people, if you want to mark up your bags, and it's easy for someone to want to say, hey, this is a Gucci bag, because you can get that selling point price based off of their goodwill, the money that they've spent building their brand to be this luxury brand. So trademarks are a big deal. And most people, if you have a business or even what you're doing, you should the makeup line, or if you have a particular name for your brand, your group of products or the company itself, you can get a trademark for that. Then you have copyright. So things like books, artwork, creative things that don't have utility aspects to it. You can get a copyright for that. And again, that's going to prevent somebody else from copying what your intellectual property is. And so you want to prevent people from misappropriating, what your assets are, because it's an asset.
Right. So, like, if I have a business idea that I've brought into fruition, let's take my me being a makeup artist, and the fact that well, I guess it's sort of a good or a service or whatever. Would that come under the intellectual property, or
Well,
would my
so
name, like Godsbratt and her paint, is that something that I would want to trademark or copyright?
So, as a makeup artist, you would be providing a service, right? You're going to
Mm-hmm.
be applying makeup services for people. And
Mm-hmm.
so, for services, you cannot get patents. That's going to fall under trademarks.
Got you.
So, what you would do, because you're going to market, whatever your name is or the name of your service, you're going to put money into marketing that. And so, you want people to identify, oh, this is Wanda's brand. And so you spend a lot of money for that. So you want to get the trademark so that other people don't try to use your mark to get some clients from you.
Okay. Okay. Hi, Camille. Camille is watching.
Hey, girl.
And so in the intellectual property realm, what are some of the aspects of protecting your intellectual property? Like when we were discussing it off camera or whatever, like what are the steps taken to say, okay, this is Wanda's intellectual property? What are the steps taken to get a patent? How expensive is it? Is it expensive? All of those things. I want to know.
So normally what would happen is someone would call you and you would do a consultation and you would say, hey, tell me a little bit more about what you're doing. And you would tell me, hey, I'm a makeup artist. I provide these services. Maybe you even have developed some products of your own. You're selling t-shirts, whatever the case is. So the potential client is going to tell me what they're doing. And based on what they're telling me, I'm going to make recommendations to them. So I would say, oh, okay, this is something that you could get a trademark for, or here's something, this aspect you might want to get a copyright for, or this is something you can get a patent for. Patents they're not easy to get because you get a 20-year monopoly on whatever your innovation is. So those are out of all of the intellectual property rights. Those are the hardest to get. So if you have a patent, the way that process works, I always recommend someone have a search to do a patent search. So it's nothing worse. You can't get a refund from the patent office. So if you spend money to have an application drafted, submit it to the patent office, there's a patent examiner that's going to pick up your application. They're going to review it. They have a whole bunch of requirements that every application needs to meet. The biggest ones are novelty and non-obvious.
Mm-hmm.
And so basically what that means is your innovation was not already innovated. Someone else didn't already do it.
Okay.
So that's the novelty aspect. It's new. The non-obvious aspect is, well, it's not totally brand new, but it's a modification of something else. And that's kind of obvious to do. So we're not going to let you get a patent for that.
Mm-hmm.
So you have to meet both of those hurdles. And once you do that, then you'll get a patent. But your protection is really based on what the claim. So every patent application, it have different parts. It's you have a description of how to make and use whatever your innovation is, and then at the end of the application, there's a set of claims. The claims really define what your the boundaries, the breadth of what your protection, what you have rights on,
Okay.
and so usually the attorney we try to draft the claims as broad as possible, but the patent examiners typically, when you do that, they're going to dump the book at you. Well, this reads on everything. If you say, well, I have a car, well, what kind of car? You need to say the car has 4 doors or the car has a solar power versus whatever. You can't be that broad. So it's something you definitely want. You would need to definitely get a patent attorney. I always recommend people because it's not easy, to go through that process. It can take 2 to 5 years. They do have an expedited examination process for a fee. Everything for a fee, you can maybe get
Mhm.
things done quicker at the patent office. It's
Right.
going to probably cost you anywhere from $10,000 to $15,000 for a
Wow.
patent. Now, for trademarks, it doesn't cost that much. Trademarks, the trademark application itself usually is about $1,500, and then the trademark office assesses a filing fee, a registration fee for each mark that you want to register. So
Mhm.
if you Oprah, for instance, Oprah has over 100, 200 trademarks. She has
Okay.
Oprah, Harpo, all sorts of things. And she has them registered in multiple different classes. So when I say class, so for example, you can have t-shirts
Mhm.
versus appliances versus paint versus, I don't know, barrettes or something to that effect. All of those have different classifications at the trademark office. And so if you want to register them in the different classes, that's where the money starts to pile up. So, of course, the broader, the more protection that you have, the more, the stronger your rights are. So, it's always a balancing act with a lot of the startups and, folks that don't have big budgets because they just don't have
Mhm.
a lot of financial resources to do that. So, typically, some protection is better than none, of course, and you can
Right.
always expand as you go. So, but typically
So
you
for
want.
like my girlfriends that have I have several girlfriends that have t-shirt businesses, and like one has what she calls the note line, which is like note to defeat and note to anxiety and note to depression, which is her intellectual property in my mind. Is that something
Right.
that's hi Denise? Is that something that's considered intellectual property, her note line? And is that something she would want to try to
So she could definitely get a copyright for
Mhm.
that specific design,
Mhm.
all the different ones, and she could do it as a collection if she has like a collection, a different series of them. But
Mhm.
when you're talking about the trademark has to be the marketing phrase or the thing that you market your goods and services under. So if she has, let's say she has a website and it
Mhm.
says, this is the No Line series or something, or I don't know, I'm trying to think of a broad name that she could
Mhm.
reference all of the t-shirts under. And
Mhm.
then she could market it. Hey, I'm selling my No Line series on the website. And then she could trademark No Line series because you're marketing the
Mhm.
t-shirts under the name No Line series. So,
Gotcha.
but each t-shirt, if it says no to anxiety or, the different iterations of how the t-shirts are set up,
Mhm.
unless you're marketing them um, in the same way I just described as you would if you say the No Line series, you're not going to be able to get a trademark. So that's the only thing with a trademark. It has to be like a brand name. It has to be the name that you market your goods and services under.
Okay, so her name is Kenby, and it's spelled a certain way, and of course I forgot exactly what it means. So would Kenby be the trademark? I'm
Could
just trying to
be.
understand. Okay,
It could
gotcha.
be. So
And she
if
does have
her
it. Hmm.
So the thing with the trademark, when you file an application, you have to first of all, you have to be using the mark in interstate commerce. And that just simply means that you are marketing to sell your goods or services across state lines. So the
Hmm.
easiest way that people get over that requirement is just to have a website, right? Because anyone in the country can access your website. So
Right.
that's going across state lines. So if you have a website set up, and when you get to the landing page, if it says there, it can be store or whatever the case is.
Hmm.
And under that, on the page, she has the different items that she's selling under that brand. You could do it that way
Okay. So now,
because
oh, I'm sorry, I'm jumping all over the because I'm just
no,
thinking
no,
of different businesses. Now, one of my well, I have several girlfriends that are authors. Um, One is actually making moves, and her book is being shopped around for Hollywood. Others are like poets and things of that nature. Are those things that would qualify as the intellectual property? And
so books and stuff like that are definitely copyrights. You can get a copyright for your
okay,
books,
okay.
definitely. Um, and so the thing, it gets tricky because, think about it. Some of the movies we've seen, 400 Jason thriller movies, we've seen
Hmm.
400 romantic, someone stuck on the island. So you can't prevent other people from using the idea, but they can't literally copy your version of your creation. So the same names, the same stories, things, events happen the same way.
Hmm.
Um, so it prevents literal copying, but it does not stop someone from capturing your concept or your idea and then applying it, in another story or whatever they want to do with it. So
Something sort of similar, but yeah,
yeah.
okay, got you. Now, what are some like? What are some of the things that you feel like anybody that is trying to protect their intellectual property, because I obviously didn't know, what are some of the
Mhm.
most important aspects that you think they should know going forward, like if they want to protect their intellectual property? Like, I'm a novice walking in, what would you tell me that this is what you need to do?
I mean, I would definitely say do your research, and because you're going to know what you're doing in terms of the different. So, like I said, you have the different classifications. And
Mm-hmm.
so I just think people need to try to be more informed
Mm-hmm.
because sometimes people may have intellectual property that they don't realize that they have.
Mm-hmm.
And, you don't want to miss out on being able to get the protection for your intellectual property so that you can license it. I mean, it's an asset. You can will it. It could be a part of your legacy. I mean, there are lots
Mm-hmm.
of things you can do. So I just think people, like this podcast, and then, if folks, I'm sure there's a bunch of information on the website, on the internet about intellectual property in general. I would just say folks should just try to maybe learn more about it in general. And then if you feel like, hey, I'm doing something that may fall into one of these categories, I think typically you can get a 15 or 30-minute free consultation, typically with an IP attorney, and they will be happy to say, hey, what are you working on? And they would make recommendations and things of that nature. So my biggest thing would be don't lose out on the opportunity to get intellectual property rights if you have intellectual property.
Mm-hmm.
Um, so just maybe, do a little research and maybe learn a little bit more about it in general and see if it applies to, what you're doing. Because a lot of people, especially entrepreneurs or people that are starting up companies and stuff like that, a lot of times they definitely have intellectual property.
Right, and I was hoping to have more people on, because I know a slew of entrepreneurs on the website, and they'll, if they look at this podcast later and say, I really need to speak with her, and what services does she provide? What do you provide? How can they get in contact with you, and all of that information?
Sure,
Because I
yeah.
was purposeful in not putting your business on your company name on the flyer.
Okay. So I am currently working at Fishman Stewart. I recently just merged my firm with their firm. So I'm up counsel with Fishman Stewart. So I have to service all of my clients through that law firm. And so if they want to, if anyone wants to reach out to me, my bio is on the website at www.fishstewip.com. And I also have a LinkedIn page under Kimberly McLean. And honestly, if you Google me, I think my website will come up from my law firm where it'll still have an email address or something to that effect that will allow you to communicate with me. But I would just have to, provide any services through the newer firm. But you can still
Okay.
contact me through that information.
Okay.
Oh, and I do all areas of intellectual property: patents, trademarks, copyrights, and trade secrets.
Can you
So,
explain the difference between each one for someone like myself?
yeah, yeah. So patents is basically it's a monopoly to prevent other people from making or using whatever your invention is. Those are inventions. Those are processes, methods, articles of manufacturers, things that you create that people can use, and it has some utility aspect to it. It has to have a utility component to it that's new and not obvious. So, for example, think of smartphones, your TV, appliances, autonomous vehicles. Those are all things that you can get a patent for. But even simpler things, it could be. I worked with a lady who had a foot dryer. Another young lady had a special blow dryer that she came up with. Someone had a mechanism that they use to help people do weaves, quicker weave things for someone's hair. So that's what I'm saying. That's still a mechanism that has some utility aspect to it.
Okay.
So trademarks has nothing to do with utility. It's all about how do you market your goods and services. And the whole idea is to protect that. People spend tons of Starbucks, the company is who it is because of all of the marketing. Think about how much people spend for Super Bowl ads. So they spend a lot of money for marketing so that you remember that Starbucks has this Frappuccino and Gucci has this bag and Louis Vuitton has this, and red bottoms from Louis Vuittons or whatever, because they market that. So they trademark that stuff so that you can't come with your knockoff red bottom shoe and try to then say this is $500 because this is a Louis Vuitton shoe, something to that effect.
Right.
So your trademarks are your brand names, and it's basically protecting the goodwill that you have put into presenting to the world, what your company is, the goods or services, and you don't want copycats, people trying to sort of steal your brand for their own stuff.
Okay.
Copyrights simply, it's a lot of literary works, your books, poems, mechanical drawings, artwork, things of like a lot of creative things that aren't brands, that don't have any utility. A lot of that stuff is going to fall under copyrights.
Okay.
And in trade secrets, a lot of times, because sometimes people come to me and they have, I have a recipe, or I have a new barbecue sauce, that I came up with. Can I get a patent for it? And technically, you can get a patent for recipes, but they're very difficult to do because almost every combination of known ingredients, the examiners are going to say it's obvious, right? It's obvious to try a different combination of recipes and things of this nature. So it really has to be something off the hook. I
That
mean,
makes
way
that
off the
recipe
cuff.
stand out.
Yeah, like something, I don't know, you're putting aloe vera and lemonade. I don't know, because it, you discovered it has some different property to it, and it does something, I don't know, to the beverage. So, but for stuff like that, that's going to be more of your trade secrets. Then Coca-Cola has the world famous trade secret. Nobody knows what the formula is. So, and they haven't told anyone, and they don't have any kind of other intellectual property. It is a trade secret. So those things are covered through NDAs, because if you have to have someone make it, you want to have a non-disclosure agreement that prevents them from telling anyone what the ingredients are, things of that nature. So a lot of that stuff is governed by contracts.
Mm.
So they all are kind of different, and they protect different things.
I'm glad that you were able to break that down because, girl, I was doing my research. I was online and I had look. I had a whole slew of things, but I was like, let me just get her to explain it because that's better than me sitting up there reading. She's the expert here. So
Yes.
it's like and you corrected me, not 20 years experience, but you have quite a few years experience. You started elsewhere, but what would you recommend the first step if someone thinks they need to utilize yourself or to protect their intellectual property? What is the actual first step? Like,
So depending on what it is. So for patents, I would say you want to keep it like sort of confidential because someone can steal your idea if you just tell them or something to that.
right.
If you don't have a non-disclosure agreement or any kind of contract that obligates them to a confidentiality
Mm-hmm.
aspect. So for anything that falls on the head, I think I may have an invention. I would say, don't do any public disclosures without NDAs, something to that effect. For
Mm-hmm.
trademarks, part of you have to use a mark to get a trademark. So there's nothing, um, you don't need to. Nothing confidential about that. In fact, the sooner you use it, the better. Because the first to use has the priority rights for a trademark. So I don't know if it's me. I was getting an echo all of a sudden.
Oh, wait a minute. Let me see if I turn. I don't know. I'm not hearing it, but let me turn my.
Oh,
It's
okay.
okay.
I don't think I hear it anymore. Okay.
Okay, I turned my volume down. Maybe it was bouncing off.
Right.
Now, in the case where two people are claiming to have intellectual property, and they have the same idea per se, how is that normally resolved?
So that's a that's a loaded question. But so it depends. So for example, with trademarks, it's first to use and in the geographical region that you're using it. So this has happened often where someone is using a mark and they're selling at the farmers market,
Mm-hmm.
at a local market, and they have labels and everything made with their brand name on it and that sort of thing. And then they decide that they want to go and register it.
Mm-hmm.
And they discover that someone has already um, registered the mark. Let's say it's the same mark.
Mm-hmm.
So the whole problem comes when when you register your mark, you are presumed to be the priority user,
Mm-hmm.
and so it's a rebuttable presumption, meaning you can be proved to be not true. But that means you got to go to court, you got to pay a lawyer, you got to have evidence, you got to spend the money to prove that you were the first user. And typically, people with smaller budgets, they don't have the money to do that. So they wind up just changing their mark. So it's always a good idea, I think, before you spend any money on any name or logo or anything that you want to use for trademarks, to do a search. You can do a search. The trademark office has a public database. You can put in terms, you can, search for if you're using particular words or phrases. And
Mm-hmm.
if you're really going to be putting money into it, you could just pay, they have third parties that do trademark searches. And just have someone do a search. These are called clearance sort of studies or analysis, where you check out what's already out there on the market before you put your money into it or start doing it.
Mm-hmm.
Because if you don't have the priority rights and you don't have the money to defend it, then all you can do is change your mark. So
Right.
now
Okay.
with copyrights, if two people independently create the same thing, then they both just get a copyright. So,
Mm-hmm.
but it would have to be proven, right? So, and that's not likely, but the idea is if you create something independently on your own, you didn't copy from someone, then they can't stop you from getting a copyright. What you would have to prove is that person has somehow had access to, what you were doing, and they were predisposed to this information. And so they, that's how they came out with it. But if someone on the moon created this and you're here and they don't, they don't have the internet in the moon, it's like, no, they didn't have access
to it. They didn't copy you. You just had similar ideas, right, so to speak. Okay.
Now with patents, it gets a little complicated because it depends. Because technically you can have two people that file an application and you don't know about the other person that has filed an application on the same thing because you guys are pending and going through the process at the same time. Okay. So the examiners can only use it's called prior art, which is basically any public documents or information. They can only use what's in the public domain to say, hey, this, to compare what you're doing to what's already in the public, to say whether it's new or not. So if someone's going on the same track with you, what happens at the end of that is they have to do inter partes appeal, and then it's going to get down to the U.S. is a first to file system. We used to be first to invent, but it didn't. In that case, it would come down to the first to invent. So you would have to prove, again, technical notebooks or whatever. Hey, I work with this prototype company. Things that you can show dates and time frames to reference that you were the prior user. You would have to prove all that. So it gets to be with patents, and that's definitely going to be a lot of money. Right. So, but that doesn't usually happen, that often, but it has happened.
It has happened. Okay. Well, if any of my guests, does any of the guests have any questions for Kimberly? Anyone that's live on the live? Because I can't think of any more questions. Because I didn't want to come on here acting like I was an expert. I just Googled some things, and it's like I'm just gonna get her to explain this because and you again give your contact information because people will see this later and have questions. So how do they reach you again?
Okay, so if you Google Fishman Stewart, the firm website will come up, and you can search under attorneys for Kimberly McLean. You can also Google McLean Law LLC, and that's going to bring up an email, or at least a form that you can send to me, and I will be able to get your contact information that way. I am also on LinkedIn under Kimberly McLean, and my email, my regular email, I can just give it to them now. It's so it's kmclean@fishstewip.com or kim.mclean@mcleanlawllc.com.
Okay, wonderful. Kimberly, I want to thank you for coming on and explaining something that I knew nothing about. I'm always trying to learn. Watching Wanda's World is about bringing positivity, about bringing knowledge, about being inspirational. I want to thank you for being an inspiration to young Black girls because representation is important, and you are a Black lawyer, a female Black lawyer. So kudos, queen. Kudos. Representation is important. So on that level, I want to talk about that. How did you, what was the journey? Like you told us a little part of it, but that, we used to hang together at Camille's house and everything. How did us hanging together evolve into this professional Black woman, this Black woman attorney that I see now? Like, give me your thought processes.
My journey has been well, it's been, I've had some challenges. particularly in electrical engineering, there aren't a lot of African American women. There aren't a lot of women, period. So
Mm.
it's generally a male. At least when I was going to school and first started working in the industry, it's a male dominated field, and typically white male dominated. But now you have a lot of Asians, you have a lot of Indians, you have a lot of people in the tech sector, and you even have more women. But that's why they have STEM programs now. They want to reach
Mhm.
women to get them involved in the science and engineering and technology areas. So, but when I was coming up, I was the only woman, the only Black, that sort of thing. So it was, you had to be able to navigate through that and not feel, um, you know, um, that you were somehow like everyone's like, oh, she's the only Black girl here, that kind of thing. It just
Mhm.
kind of treat you, hopefully everyone looked at me as another engineer and that kind of thing. So, I mean, I can't say that I don't readily feel like I had any particularly racist sort of incidents, but,
Mhm.
um, you know, there could be subtle things, maybe not as much help, or
Mhm.
you kind of have to fend for yourself, or that kind of thing. So that was definitely a challenge. Definitely in when I worked in engineering, I worked at Texas Instruments and Miter Corporation, and it was so it was tough, but I got through it. Um, but it depends on the person. I have a very tough disposition. It takes a lot to kind of rattle me,
Mhm.
and I'm determined to get done what I need to get done. So I have thick skin, and so I was able to kind of navigate that terrain without it tearing me apart too much.
Mhm.
But and it just, I think, has made me a stronger person, and more confident.
Mhm.
And that was always my disposition. Hey, I have an engineering degree just like you. I have the same knowledge as you. You may have more experience. I mean, so I can do this same job just like you. And
Right.
so let me show you what I can do. So
Right. So for the young ladies out there that may see this later, let nothing or no one deter you. Let no
that's
one make
right.
you feel inferior. Let no one make you feel like because you may not have come from the background that they have come from this privileged elite background that you can't be. I also mentor young ladies, and
Hmm.
one thing I like to tell my young ladies, you do not have to be a product of your environment or circumstance. And I
Yes.
am definitely an example of that. I
Yes.
had so many challenges in life and I rose above them because I was always like, I'm not going to be a victim. I'm not going to be
Yes.
anybody's victim. I'm not going to let nobody tell me that I'm
Yes.
less than just because I didn't come from this privileged background. I'm going to get it done.
Exactly. No, and that's such great advice. And I think, that's another thing that's important, I think, in the African American community, mentorship, right? Really having someone there to kind of cheer you on and give you good advice and pick you out when you're down, and just kind of let you know you're not alone, and just having that wisdom to say, hey, I've been there, things get better, or hey, you don't have to, go this way or take that route, that sort of thing. So I'm a big advocate of mentorship. I feel like, if I had mentorship, I probably would have gotten a lot further quicker than learning
Mhm.
by fire all the time,
Right.
because fire does burn. But
Right. Exactly.
so it, like you said, more of us out here, we can mentor the younger people. I've had several people reach out to me on LinkedIn, wanting to, hey, can you be a mentor? I'm thinking about getting into law or patent law or things of that nature. And I definitely want to make time, even if it's, I don't know, just to do lunch or quick call with these folks. But I think that's so important,
Hmm.
in terms of advancing the younger people, in the right direction. So,
And also surround yourself by strong with strong sisters. You have to have a strong
mhm.
sisterhood. Like Kimberly and my cousin Camille have been friends since they were young. I have friends since I was 11 years old. I'm 53 years
Mhm.
old now.
Mhm.
So one,
Yeah,
the sisterhood, like find your people. And then also don't always try to be the smartest person in the room. I'm always looking for, like, I don't
yep,
always want to be the smartest person in the room. I want to get in the room with the people that know more than me because I'm trying to
exactly.
learn.
Yep,
So, it may feel good for a moment, but you're going to be stagnant if you're always the smartest person in the room. Put yourself in rooms and then also surround yourself with people that'll mention you in rooms your feet have never stepped in.
that's right. There you go.
So that's how I try to live my life and teach my girls and everything. So I just wanted to put that out there. I'm gonna play my little outro, which is a commercial for one of the groups. I am a makeup artist and I do
Okay.
represent two makeup brands, one being Plan and Makeup by Yolando. If you go to that website, planandmakeupbyyolando.com, you can use code WANDA, WANDA, to save you some coins. But I want to represent Respect the Crown.
Okay.
And if you go to Respect the Crown, my
Right.
code is Lady W, all together. And I'm going to play that little outro, my little commercial, and then we'll come back, say goodbye to Kimberly, and say goodbye to each other until next week, And of course, I'll be playing this back throughout the week for those people that have missed the broadcast and everything. But I thank you all for rocking with me, for joining, watching Wanda's World to see what's going on in my little space and everything. And I hope you enjoy the content that I bring. So I'm going to play my little commercial for Respect the Crown. And so bear with.
Can I call you Rose? 'Cause you're sweet like a flower in bloom. Can I call you Rose? 'Cause your fragrance takes over the room. Darling.
So that's my commercial. I gotta update it because the code used to be Lady Godsbratt. It is now Lady W. Remember that. I'm saying it, Lady W. And affordable black owned. Both of these brands that I
Oh,
represent, black owned by black women. And y'all, this is a full face of Respect the Crown.
yes.
Skin is skinning.
Yes.
So affordable makeup by a black woman, and she'll run a sale. You can get a discount with my code, but it's affordable and it's good. It's good. So anyway, so Kimberly, I want to thank you for joining me tonight. Thank you for agreeing to be on my show. Thank you for educating me. I had no clue. I feel like I've learned something tonight. I'm always trying to learn something. Is there anything that you'd like to say in closing?
No, I just want to say I enjoyed having this conversation with you, and I hope everyone learned something. And feel free to contact me if you need anything.
Wonderful. Okay, so with that, I'm going to say, as you go about your day, if you see a queen and her crown is a little twisted, it's crooked, it's done falling off, help that queen do whatever she can do, you can do to help her get that crown back on her head and aligned properly. Whatever you do to help that queen get her crown back in position, zip your lips. We need to be our sisters' keepers. It is not your place to tell what you had to do to get that queen and her crown back in position, because if you did that, you did it for recognition, not for her good. We need to be our sisters' keepers. So, with that, I'm going to say peace and blessings. Remember, the enemy separates and we unify. I love you to life, and there's nothing you can do about it. Kimberly, stay on for a second.